9 years to the day, Margaret Ashworth walked back into courtroom 3 and took the same oath she had taken once before, and the attorney across the room was already shaking his head before she sat down. "Mrs. Ashworth," he said, "you understand this hearing exists because your claim is, at its core, a story. A beautiful one. But a story." She folded her hands on the table. She did not look away from him. "It's not a story," she said. "It's a Tuesday in March. I remember the Tuesday." The room did not yet understand what that meant. The court reporter did. Doreen Albright had been transcribing hearings in this building for 19 years, and she had learned to feel the weight of a room before she could name it. This one had weight. She had typed thousands of opening lines. Custody disputes. Property liens. Men shouting about fences as though the fence were the whole of their lives. She knew the rhythm of a routine hearing the way a nurse knows a normal heartbeat, and this one didn't have it. Margaret sat too still. People who invent things tend to perform them, to look for an audience, to fill silences with extra detail no one asked for. Margaret looked only at the calendar on the wall by the clerk's station, March 14th, as if she'd been counting toward that date for longer than anyone in the room could guess. Doreen had seen the file come in 2 weeks earlier. Supplemental Survivor Benefit Appeal, filed pro se, no attorney, against a pension office with 3 staff attorneys and no urgency to settle. She had assumed, the way most people in the building assumed, that it would end the way most pro se appeals against institutions ended. The attorney, a sharp young man named Foster Rye who represented the pension office's appeals division, opened a folder he had clearly rehearsed opening. "Let's establish the facts as filed. Your husband, Corporal Daniel Ashworth, was deployed in 2017. He died in service in 2018. You are seeking a supplemental survivor's benefit based on a verbal promise you say he made before deployment, that upon his return, certain accrued combat-related compensation would be assigned to you, structured a particular way, for tax and inheritance purposes. There is no signed beneficiary form reflecting this. There is no notarized document. There is only your testimony, given 9 years after the fact, about a private conversation no one else heard." "That's right," Margaret said. "And isn't it true," Rye said, "that the timing of this claim, filed only after the standard survivor benefit was nearly exhausted, suggests it was constructed to extend a payment stream that was always meant to end?" A murmur went through the gallery. Doreen's fingers did not stop moving on the keys, but something in her chest tightened. "It's not constructed," Margaret said. "It's remembered. With respect, Mrs. Ashworth, memory is not evidence. The court cannot award supplemental benefits on the strength of sentiment." Rye turned to the bench. "Your Honor, I move to strike the claimant's testimony as unsupported and ask that the appeal be dismissed with prejudice. This is, at best, a grieving widow's convenient recollection. At worst," he paused, as if weighing whether to say it, then said it anyway, "it's a fabrication dressed in mourning." The word landed hard. A fabrication. Doreen typed it exactly as spoken, because that was her job, but she felt the unfairness of it travel down her arms into her hands. Margaret did not flinch. She did not raise her voice. "I was 26 years old," she said, "standing on a tarmac in the rain, and he held my face in both hands and told me what he wanted done if he didn't come back. He said it once. He never wrote it down because he never thought he'd need to. I have lived with that conversation every day since. I did not file late because I invented something. I filed late because for 8 years I could not bring myself to turn his last promise into a line item." Rye did not let the silence sit. "A touching account, Mrs. Ashworth. But this court has seen touching accounts before, and the law requires more than a touching account. Can you produce a single document, a letter, a witness, anything contemporaneous to March of 2017, that corroborates this conversation took place at all?" "No," Margaret said. "There was no one else on that tarmac." "Then we are left with your word, 9 years removed, against a benefit structure designed to prevent exactly this kind of after-the-fact claim." He let that sit a moment, satisfied, and gathered his papers as if the matter were already settled in his favor. Judge Holbrook, presiding, said nothing yet. She was listening the way good judges listen, not for sympathy, but for a thread she could pull. "Counsel," the judge said to Rye, "do you have anything beyond the timing of the filing to support a finding of fabrication? Anything at all?" The absence of corroboration is itself telling, Your Honor. Absence isn't evidence either, the judge said evenly. It's just absence. She turned to the clerk. Has the original 2018 casualty and benefits intake file been pulled? The full file, not the summary. The clerk hesitated. Your Honor, the original intake file from that year is archived off-site. It would take. Then we'll wait, the judge said. This hearing is in recess until the file is produced. I want every page that was submitted at the time of death notification, not just what's been digitized since. Rye's confidence didn't waver. He believed, plainly, that an old file would contain nothing but what had already been said, and he used the recess to lean toward his second chair and murmur something that made them both glance, briefly, at Margaret with the particular pity people reserve for someone they've already decided has lost. Doreen watched him settle back into his chair, almost relaxed, certain that silence, 9 years of it, would finally win the day for the office that employed him. The recess lasted 40 minutes. When the clerk returned, she carried a banker's box that smelled of basement storage, dust rising off the lid when she set it on the evidence table. Margaret watched the box the whole time, hands still folded, as though she had learned long ago that hoping out loud only made waiting harder. Inside, beneath casualty notification forms and a folded flag receipt and a thick stack of insurance paperwork no one had touched in years, was a sealed manila envelope that had never been opened because no one had ever had reason to open it. What is that? Judge Holbrook asked. It's marked, Correspondence, Unit Chaplain, March 2018, the clerk said, turning the envelope over. It looks like it came in with the rest of the casualty packet and was filed without review. The original benefits process didn't require it, so it was just kept. Open it. Inside was a single typed letter on Army chaplaincy letterhead, dated 11 days after Corporal Ashworth's death. Margaret had never seen it. She had not known it existed. Her hands, folded the entire hearing, finally unclasped, pressed flat against the table as if she needed something solid under them. The judge read it silently first, her expression unreadable, and then she read it aloud, so the record would carry every word. To whom it may concern. I am writing to document a conversation Corporal Daniel Ashworth initiated with me on the morning of his deployment, March 14, 2017, prior to departure. He asked that, in the event of his death, I record for any future need that he had informed his wife, Margaret Ashworth, of his wish that his combat-related compensation be assigned to her under a structured arrangement, separate from standard survivor benefits, for the purpose of long-term financial protection. He stated he had not yet completed the paperwork and was concerned he would not have time before departure. He asked that this conversation be put in writing in case it was ever needed. I am submitting this letter as part of his casualty file as a matter of record, per his request, dated and signed below. The chaplain's signature followed. The date followed. March 25, 2018. Filed with the casualty packet. Sealed. Forgotten by a system that had no checkbox for a promise. Doreen Albright's hand stopped moving for the first time in 19 years of transcribing hearings. She had to remind herself to keep typing, that the record needed every word, that her own astonishment was not part of the proceedings. But she felt it anyway, the particular vertigo of watching a thing she'd assumed was sentiment turn out to have been documented, in writing, by a stranger, 11 days after a man's death, exactly as the widow across the room had described it. Rye's face had gone the color of old paper. Your Honor, that document was never disclosed in discovery. It was in your own client's file, the judge said. Filed 9 years before this hearing, Mr. Rye. 11 days after his death. Before any benefits claim of any kind existed to construct. Before Mrs. Ashworth could have known it was there, let alone planted it. She set the letter down with deliberate care, as if it deserved to be handled gently. You stood in my courtroom and called a grieving widow's memory a fabrication. The record now shows her memory was corroborated, independently, by a chaplain, in writing, while your client's own office had it in storage the entire time. I didn't know it existed, Rye said. That may be true, the judge said. But you didn't ask. You assumed absence meant invention, and you said so on the record, in open court, about a woman who buried her husband at 27. That is not advocacy. That is a failure of diligence dressed up as certainty, and the court will not let it stand uncorrected. She turned to the full room. The motion to strike is denied. The claimant's testimony is corroborated. The supplemental benefit is granted, retroactive to the date of the original casualty filing, with interest calculated from that date. A finding of bad faith is entered against the Appeals Division for failure to produce material evidence already in its possession, and a copy of this finding, along with the full transcript, will be forwarded to the State Bar's Office of Professional Responsibility for review of counsel's conduct in characterizing sworn testimony as fabrication without basis. Rai said nothing. There was nothing left to say that the room would have believed. His second chair did not look at him. Somewhere behind them, a man in the gallery who had come for an unrelated hearing leaned toward his neighbor and whispered something that made them both go quiet and watch the front of the room instead. Margaret sat very still. She did not cry, though something in her shoulders loosened that had been held tight for 9 years. She had not come into that courtroom for vindication. She had come because she remembered a Tuesday in March, and she had been willing to be doubted for telling the truth about it. Mrs. Ashworth, the judge said, her voice softer now, the court regrets that it took an old letter to be believed when your word should have been enough. It wasn't enough today. It will be enough from now on. He kept his promise, Margaret said quietly. I just needed the room to know I'd kept mine. Doreen Albright finished the transcript that afternoon the way she finished every transcript, methodically, line by line, checking each name against the audio, each timestamp against the recording. But when she reached the chaplain's letter, she read it 3 times before moving on, and the third time she found she had to stop and look out the window at the parking lot for a moment before her hands would work again. 19 years of hearings had taught her that most testimony was ordinary: bills, blame, exhaustion. She had not expected, on an unremarkable Tuesday, to type out a dead man's last instruction and feel it land in her own chest like something meant for her. That night she called her own husband, who was stationed 2 states away on a training rotation, and she told him she loved him, and then, because the day demanded it, she told him to write things down, the small instructions, the wishes he assumed he'd never need to say twice, just in case, because 9 years was a long time to carry a promise alone, and some promises deserved to outlive the people who made them. He laughed, gently, and asked what had gotten into her, and she said only that she'd watched a woman wait 9 years to be believed, and she didn't want anyone she loved to ever have to wait that long. The hearing room cleared slowly. The clerk filed the chaplain's letter properly this time, into a record that would never again call it absent, sliding it into a folder marked with Margaret's case number in handwriting steadier than the morning's had been. Rai gathered his papers without speaking to anyone and left through the side door reserved for attorneys who wanted to avoid the hallway. Margaret did not avoid the hallway. She walked through it the way she'd walked into the courtroom, unhurried, upright, neither rushing toward relief nor away from what it had cost her to get there. An old woman who had sat through the entire proceeding without saying a word, there for some other docket entirely, reached out and touched Margaret's sleeve as she passed. I believed you before they read it, the woman said. I know, Margaret said. But I'm glad they read it anyway. It matters, doesn't it? Being believed before the proof comes. It matters more after, Margaret said, when you've spent 9 years wondering if anyone ever would be. She walked out of the courthouse into March light, 9 years and 11 days from a tarmac in the rain, carrying nothing now but what she'd carried in all along, a promise kept, finally seen, and a dignity that had never once needed the letter to be true, only to be believed. Behind her, in a small room with a stenotype machine and a window facing the parking lot, a court reporter who had typed thousands of endings without remembering most of them knew she would remember this one for the rest of her career, not because the law had finally worked, though it had, but because a woman had walked in willing to be doubted for 9 years rather than stop telling the truth, and on the one day it mattered most, the truth had simply been waiting in a box no one had thought to open.